Rape is one of the most horrific crimes on earth. Despite its brutal, violent, and terrorizing nature, at least one person is raped every hour in the Philippines. Data obtained by the Philippine Statistics Authority from the Philippine National Police as of February 2020 indicated there were 2,162 rape cases reported to the police in 2019, 30.6% higher than the 1,656 cases reported in 2018. Rape is a crime against a person's being, a crime against the victim's soul. We sound the alarm and amplify the call to end rape culture now. With both parties able to present their witnesses who completed their testimonies, to formally offer their evidence, and to submit their respective memoranda, we are now ready for the promulgation of judgment. Was the prosecution able to prove beyond reasonable doubt the elements of rape as charged to convict Roderick Digong? This is People of the Philippines versus Roderick Digong, the judgment.
Call the case.
People of the Philippines versus Roderick Gong E.D. Criminal case number RTAC-21-01013-CR for rape as defined under Article 266A, Paragraph 1A of the Revised Penal Code. Promulgation of judgment.
Appearances.
Respectfully appearing for the people, Your Honor.
For the accused, Your Honor.
Will the accused please stand?
Roderick Gong E.D. stands charged for the crime of rape as defined under Article 266A, Paragraph 1A of the Revised Penal Code as amended in an information dated October 4, 2021 by Prosecutor John Benedict M. Saoy of the Office of the City Prosecutor, Tacloban City, Leyte, the accusatory portion of which reads as follows. That on June 30, 2021, at the victim's house at Barangay 6A, Santo Niño Extension, Tacloban City, Philippines, the above-named accused be then and there willfully, unlawfully, and feloniously raped the person of AAA by inserting his penis into the complainant's vagina. That the accused forced the victim inside the latter's house, shut the door, shoved her against a concrete wall, and kissed her. The accused forced her into a room and threatened her in a pocket butterfly knife called balisong, and then removed the victim's t-shirt, shorts, and panty while pointing the balisong at her and forced her to lie down on the floor. The accused successfully penetrated her and then ejaculated. The accused then compelled her to stay on top of him, but she refused, forcing the accused to reposition himself on top of her and penetrate her a second time. That as a result of said rape, the victim suffered actual and moral damages in the amount as may be awarded by the Honorable Trial Court under the provisions of the new Civil Code, contrary to law. The sole issue to be resolved in this case is whether or not the accused should be convicted of the offense as charged in the information. The accused is charged of rape under Article 266A, Paragraph 1A of the Revised Penal Code as amended, which states as follows. Article 266A, rape, when and how committed. Rape is committed by a man who shall have carnal knowledge of the woman under any of the following circumstances. A. Through force, threat, or intimidation. The court finds that the sexual intercourse between the private complainant AAA and accused 𝗂𝗚 was consensual. As correctly pointed out by the defense, the accusations of AAA before, during, and after their sexual intercourse contradict her allegation that she was raped through force, threat, or intimidation by the accused. Evidence shows that before the alleged rape, AAA joined the accused and their neighbors who were having a drinking spree outside Dina's sari-sari store. As AAA and the accused walked to the former's house to get pulutan, the latter put his arm around her shoulder. AAA was then seen to have opened the door for the accused upon arrival at her house. The CCTV footage shows the two acting very closely, conversing and laughing together after the two came out of AAA's house and on their way back to Dina's sari-sari store. This conduct only adds cloud to AAA's allegation of rape. Moreover, assuming that indeed AAA and the accused had sex, the former's testimony reveals that no force, threat, or intimidation was exerted upon her person. The manner by which AAA was allegedly raped is unbelievable. According to her, accused repetitively kissed her lips, breasts, neck, and vaginal area. After the accused ejaculated on the first penetration, the latter knelt in front of her and engaged in foreplay by kissing her vagina, lips, and breasts before having a second intercourse with her. It is simply incredible to this court that a rapist would leisurely engage in sexual intercourse with his victim, as what happened in this case. A man who intends to rape a woman would normally not go through the rigors of sexual foreplay after his lust is satisfied and before another round of non-consensual sexual intercourse. The absence of rape is strengthened by the absence of any external sign of physical injury on AAA's body. The testimony of Dr. Sean A. Morphe, the medical legal officer who conducted the physical and genital examination on AAA, clearly establishes this. While hymenal lacerations found in the medical certificate could have been caused by a blunt object such as the finger of a human being or an erect penis, Dr. Morphe testified that such lacerations could have also been caused by AAA previously giving birth. Moreover, no external physical or extragenital injuries were found. The Supreme Court has held that where, as in this case, abrasions and contusions on the victim's body are absent, her claim that force and violence were exerted by the accused in having sexual intercourse with her is seriously doubted. AAA narrates that she was threatened by the accused with a balisong. The balisong, however, was never presented in court. This only bolsters this court's finding that there was no force, threat, or intimidation. But even assuming that force, threat, or intimidation was present, there is no clear showing that AAA intended or even tried to resist the sexual advances. AAA's house, where the rape was alleged to have been committed, was not isolated. Evidence shows that there were plenty of people in the neighborhood at the time of the alleged rape due to the celebration of the fiesta, and that AAA was well aware of this fact. When the accused allegedly forced her into her house, shoved her against the concrete wall, and started kissing her, AAA did not shout for help, as a woman would instinctively do. Even during the alleged sexual assault, AAA did not actively defend herself. It appears illogical to this court that AAA would not struggle against the removal of the shield of the very object of the accused's lust. The Supreme Court has ruled that mere attempt to resist is not the resistance expected and required of a woman defending her honor and chastity. Further, AAA had every opportunity to escape from the accused but chose not to. AAA admitted in her testimony that after their first sexual intercourse, accused compelled her to be on top of him, but she refused and instead maintained her original position where she was under. While this court recognizes that rape victims react differently to sexual assault, AAA's conduct taken in its entirety indubitably casts doubt on her credibility and the veracity of her assertion. Time and again, the Supreme Court has ruled that when the guilt of the accused has not been proven with moral certainty, the presumption of innocence of the accused must be favored and his exoneration be granted as a matter of right. Wherefore, premises considered, this court finds the accused not guilty on the ground of reasonable doubt, and his immediate release from prison is hereby ordered, unless he is otherwise detained for any other lawful or valid cause. So ordered.
Order. Judgment was promulgated to accused 𝗺𝗱𝗲𝗂𝗏, assisted by his counsel, Attorney 𝗂𝗁𝗂𝗍𝗂𝗍𝗂𝗏, in the presence of Public Prosecutor 𝗺𝗵𝗱𝗲𝗂𝗏 and Private Complainant AAA. Accused 𝗺𝗱𝗲𝗂𝗏 is found not guilty of the crime charged against him. The warden of the Tacloban City Jail is directed that 𝗺𝗱𝗲𝗂𝗏 be immediately released unless he is otherwise being held for some other lawful or valid cause. So ordered.
Mga kabalitaktakan, adi ang naglalagatak nga balita, tikang han syudad han Tacloban, tuktok masasaligan. Ini an Bali Tacloban.
Mga kabalitaktakan, formal nga nagpalusad ang RTC Branch 8 Presiding Judge Jose Vivero hindesisyon pabor kan 𝗺𝗱𝗲𝗂𝗏. Para han bugos nga balita, adyan aton kabalitaktakan, Hex Montero. Hex?
Mga kabalitaktakan, malipayon hinduro hi 𝗺𝗱𝗲𝗂𝗏 an iya pamilya upod na ni abogada nga hi Attorney 𝗂𝗁𝗂𝗍𝗂𝗏 matapos magpalusa din desisyon ng RTC Branch 8 nga not guilty o pabor kan 𝗺𝗱𝗲𝗂𝗏.
Malipayon kami nga sa wakas na tagan justisya ang malisyoso nga pagpasaka ng kaso ni kan 𝗺𝗱𝗲𝗏. Ang desisyon ng korte pumabor kan 𝗺𝗱𝗲𝗏 sugad kay napuod kami nga waray good ray ka ng tabo. Kay una, waray force or intimidation nga nakita ang korte, which is amo ang ginalleged information han aton private complainant. Ikaduha, waray extragenital physical injury nga nadiskubre ang aton eksperto ha medico-legal nga ma-attribute ha panlugos ni 𝗺𝗱𝗏. Ngan masasabtan gyud nato nga basihan mga ebidensya lalo na ang CCTV footages nga puros mga binuwa ang mga kahayag ni Jacqueline.
Sa wakas, makakaupod ko na akong pamilya. Damo induro nga salamat. Atong Panginoon, akong pamilya, kan attorney ni 𝗺𝗱𝗏𝗏, damo induro nga salamat. Ang mga malisyoso na paratang nga kumo ako kuno rapist. Ang korte na mismo nagyakan, dira ako guilty, dira ako rapist.
Tiyari pagkayana nagdilipay ang pamilya gong nga sa wakas makakaupod na nira utro haira panimalay hi 𝗺𝗱𝗲𝗂𝗏. Ini aniyo kabalitaktakan, Hex Montero. Tiyari.
Salamat, Hex. Mga kabalitaktakan, amo ito ang naglalagatak nga balita tikang syudad ng Tacloban. Haaton sunod nga pagkirigta, inihi Chari Hermosa, damo nga salamat.